Hi, and welcome to today's BCLT Advanced Life Sciences Institute program, Security Interests and Royalty Financings. My name is Allison Schmidt. I'm the director of the Life Sciences Law and Policy Center at the Berkeley Center for Law and Technology. And it is my pleasure to welcome today's speakers from Gibson Dunn, who are really the experts in this space, to share with you their expertise and their knowledge. So let me go ahead and introduce our panelists. We'll talk a little bit. So this is a part two of a three-part series. We'll talk a little bit more about that in a moment. Next slide, please. Wonderful. So we've got three terrific panelists for you today. So first is Jin-Hee Kim, who's a finance partner in the New York office of Gibson Dunn. She has extensive experience with sponsors, borrowers, arrangers, agents, and lenders, including private credit providers on complex U.S. and international financing transactions. Her experience really spans across sectors, so biotech, fintech, manufacturing, renewables, telecom, media, financial services. Are there things you don't do, Jin-Hee? Because your expertise is quite broad, which I think will really benefit our viewers today. And also in a wide variety of transactions and financing. And so we're delighted to have you with us. So our second speaker today is Anthony Hodge, who is an associate in the New York office of Gibson Dunn. He's a member of both the Finance Practice Group and the Capital Markets and Private Equity Group. So Anthony's practice focuses around representing public and private companies, private equity sponsors, and banks and non-bank lenders in a wide range of financing and corporate transactions. Third, but certainly not least, is Callie Jelen, who's an associate in the LA office of Gibson Dunn, a member of both the Finance Practice Group, Capital Markets, and Media, Entertainment, and Technology practice groups. So Callie's practice focuses around representing private equity sponsors, corporate borrowers, institutional lenders in a broad range of both banking and debt financing transactions. So as I said at the top, this is part two of a three-part series that we're putting out this month as part of the BCLT Advanced Life Sciences Institute. So if you missed part one, Royalty Finance and Structures and Trends, you definitely want to check out that program. You're able to watch that on demand through the BCLE platform at bcle.berkeley.edu. So you can go there, set up an account if you don't already have one, and download that program. We have part three on deck, which will be coming out next week, Synthetic Royalty Financing's Risks of Recharacterizing a True Sale. And so if you've not registered for that program already, you want to go ahead and do so. You can do that through the BCLT platform or through emailing us, and we'll get you on the list. So with that, I'm going to turn things over to our speakers.
Hi, we're so excited to be here today. We're here to discuss with you the importance of security interests in royalty financings. I'm here, as Allison mentioned, with my colleagues Anthony and Callie from Gibson Dunn. So just as a start with, I know we've had the part one as well that went into more details about royalty-based financings, but royalty financings or revenue-based financings involve an investor advancement of capital to a company in exchange for contractually agreed percentage of future revenue, usually derived from intellectual property or product sales. Frequently used in life sciences, which is why we're here. It is also used in other industries such as entertainment, software, and natural resource sectors. Each of these are areas where revenue streams can be forecast and collateralized. Security interests are commonly required to protect the investor's rights to receive royalties, enhance enforceability, and improve priority versus competing creditors. Usually the consideration is in upfront lump sum or in tranches tied to milestones. Investors typically receive a royalty purchase agreement or equivalent and a security agreement, sometimes combined. So I'll turn it to Anthony to talk about why security interests.
So, security interest is important in these financings because it converts a purely contractual payment obligation into an enforceable right against the debtor and third parties. It also positions the investor slash purchaser slash lender into or ahead of unsecured creditors and the debtor's capital structure. Oftentimes, these debtors all have other obligations, whether it be an equipment financier or other type of financier, and we want to ensure that this security interest has priority, particularly with respect to the royalty stream that is being financed. It also facilitates remedies such as foreclosure on receivables or step-in rights and licensing agreements, which we'll touch on a little bit more later. And it can also lower the borrower's cost of capital by reducing the perceived risk, because the security interest gives the lender the right to or access to the underlying collateral or the property of the borrower, and thus the risk is lower and can lower the interest rate.
Good morning. My name's Callie Dell, and I'm going to be talking a little bit about structuring considerations for your next royalty purchase agreement. So one thing that we sometimes see is a SPV structure, and one reason you might want to consider that for your next royalty purchase agreement is if the seller has other assets and you want to ring fence the purchase asset. So in that structure, you would typically see a sponsor at the top level. Underneath that would sit a servicer, and then underneath that would sit your SPV. The servicer would hold all of the operating liabilities that are needed to actually service the receivable. So things like any overhead costs, employees, etc. Whereas the SPV itself would only hold the purchased receivable. Some reasons that you might consider this structure is it allows to isolate the assets and ring fence them. It mitigates bankruptcy risk. It can simplify accounting and tracking processes, and it will also allow an additional form of collateral as you can pledge the equity interests in the SPV under the security interest, allowing you to simply take over the entire company rather than having to individually enforce against each asset. Some control mechanisms that you might consider putting into the operating agreement of the SPV are an independent director concept. This allows for the entity to be bankruptcy remote. That independent director is an individual who's hired from a service company for a small fee annually, and their only job is to vote in the case of a bankruptcy from a position of a third party. So it decreases the likelihood of a bankruptcy and provides additional protections. And then the other thing that you can put into the operating agreement of a SPV are limited purpose provisions. This allows you to ensure that no additional liabilities get thrown in with the receivable that you're purchasing, and ensures that like the risk of the receivable doesn't change throughout the course of the deal.
So just I think it's probably worth noting that was one structure. Not all structures do have SPVs. Sometimes the borrower does not want to, do that type of a structure. And so, but it is one way that we think about collateral and structuring and where we're taking assets. So on identifying the collateral, Anthony, if you could speak
Yep,
to that.
certainly. So there are a couple buckets of collateral here. The primary collateral is, of course, the present and future royalties, receivables, and revenue proceeds that are underlying the financed asset, the financed revenue streams. For pharmaceutical financings or healthcare financings, patents are particularly important too, because that is or patents relating to the product being financed are particularly important for these revenue streams, because that is the actual source of the product. And then also some ancillary collateral related agreements, licensing or distribution contracts, commercialization contracts, and things of that sort that relate to the underlying assets. Another important aspect of the collateral is the deposit accounts in which royalties are paid, and also other operating accounts of the borrower. These are sometimes referred to as the accounts in which royalties are paid are often referred to as collection accounts or lockbox accounts. And those are particularly important to the purchasers because that's the cash and that's the easiest place for them to be made whole in the event of exercising remedies. When it comes to special purpose entities or SPVs, equity pledges are of particularly importance for the entities that hold the IP/royalty contracts. As Callie mentioned, it allows the lenders to step in and just take control of the whole thing rather than going from one asset to another. And then also of particular importance here is a backup security interest versus a sale. A backup security interest in royalty financings is a secondary or contingent lien on additional assets or rights beyond the primary royalty stream, which give the investor/lender/purchaser added protection if the primary source of of the collateral or revenue streams fails or underperforms.
Yeah, it's also there for situations where there's a recharacterization of the sale into not a sale into a loan. And that way we usually try to consider both the sale version of the collateral as well as the backup security loan version of the collateral.
Awesome. Thanks, guys. I'm going to talk just a little bit about diligence best practices. Because of the nature of the assets in these transactions, oftentimes the diligence process can be a little heavier than your typical financing or other purchase. So the best practice when we're starting out is we typically ask for copies of the agreements with the obligors under which the receivables was created. In the healthcare space, this is usually a license or maybe a royalty purchase agreement, sale or servicing agreements. Within those documents, it's really important to look at the assignment and change of control provisions. In the event that the backup security interest is needed and the secured party needs to step into the shoes of the seller, you want to make sure that the entire agreement isn't voided or there is some other prohibition on that. If so, then you would need to go to the obligor and get a consent or otherwise an amendment to the agreement. The other thing I'll add is that if the agreement is silent as to assignability or change of control, that tends to be a local law issue. So you'd need to look to the governing law of the agreement and then go check into that state in order to confirm how it would be treated in a change of control. The other
Yes.
things that you would,
I just want to point out that, for example, if you're thinking of this as a sale, that means you're basically assigning part of the contract to the purchaser. And so if you do see a non-assignment provision, as Callie said, I just want to highlight the fact that you want to actually get the consent upfront. And
yeah,
that's tied to the collateral, but also tied to like the purchase itself.
thanks, Junhee. The other 2 points that you would typically check are the payment mechanics and the termination rights. The payment mechanics, because ideally you would be directing any payments under that contract into the lockbox if that's part of your structure. You want to make sure that you're going to be able to do that. And then the termination rights obviously goes to like the value of the receivable, making sure that it will continue for the duration of the transaction. Because we're taking a security interest, it's also important to run lean and IP searches. To the extent you're putting an SPV structure in place or otherwise you're doing this financing concurrently with like the purchase of a receivable by the seller, it's like an online or an on-selling transaction, you need to run lean and IP searches against the entity that holds the asset today, because the liens will run with the asset even if that's transferred down to an SPV or other entity. To the extent that there is IP included in the security package, you also should run IP searches to make sure that there's no intervening liens. And then the last piece, the chain of title documents are also important to the extent that the contract has been transferred before. You want to make sure that everyone has the rights that they say they have and there's no liens that have run with those previous transactions. And then finally, to the extent that the seller has secured debt in place, maybe they have like a working capital facility or something at that either top level sponsor or servicer entity, to the extent you have an SPV facility, you need to check and make sure that the sale is permitted and then also that the security interest is permitted. Sometimes the seller is unwilling to share the full versions of these documents, you would work with their finance counsel and maybe also get some sort of like either letter or consent to ensure that like this is a certificate to ensure that this is permitted under the seller's existing debt facilities. Turn it over to Anthony.
Certainly. Jinhee, do you want to take the first?
Yeah, I'll talk about this. Okay, so it's important to clearly describe the collateral under the Uniform Commercial Code, the UCC, Section 9108. You must include a description that reasonably identifies what is being provided. And so the UCC goes on to give examples of what is reasonable and some of the ways that you can, qualify under the statute is to include a specific listing, category, a quantity, a computational or allocational formula or procedure, or any other method if the identity of the collateral is objectively determinable. This is particularly important in royalty financing transactions because usually you will have very specific percentages or types of revenues, including for particular, royalty payment providers and such. And so it's really important to be precise as much as possible while making sure you're picking up all of the collateral that you're intending to pick up. Um, and just kind of also keeping in mind that we're going to talk a little bit about that later with Anthony, but perfection, how you describe the collateral in the UCC, it's going to be public. So you want to think about that. We also always include an after acquired property clause to capture future enhancements and new revenue streams to the extent necessary. But the point is that since it is a revenue stream that includes revenues that are generated essentially at a different point in time, you do want to make sure you have an after acquired property provision. So wanted to cover the granting clause there.
And when it comes to other parts of the security agreement, the affirmative covenants are quite important. One of particular importance is the segregation of royalty proceeds. Earlier, we discussed the deposit account, collections account slash lockbox. We would we would typically include a provision requiring that the revenue streams from the royalty being financed is going to be deposited into those accounts such that the lender slash purchaser has a perfected security interest in that account and the proceeds therein. We would also require affirmative covenants regarding periodic reporting for collateral, whether it be IP, registrations of new IP, acquisitions of other revenue streams or things of that sort. These are either event-driven or periodic reporting. Event-driven being, within an X amount of X period of days of filing a patent, they would need to report it to the lender, and the lender would then supplement their security interest. The next point, negative covenants. These are a mix between being in the security agreement itself versus the royalty agreement, or in the same or in both. These covenants often include restricting additional liens, transfers of IP, particularly the IP being financed, amendments to the relevant royalty generating agreements, and cross licenses. These are often hotly negotiated and tailored to the specific assets being financed. And last but not least, we certainly include and reserve step-in, audit, and offset rights to support enforcement. Audit rights let the investor verify the royalty payments and diligence the materials of the underlying debtor or seller. The step-in rights allow the investor to take control if the royalty owner fails to enforce the agreement or if they are underperforming or breaching their agreement in the event that the lender slash purchaser wants to exercise remedies. And offset rights enable the investor to recover overpayments or losses by deducting from future payments. And perfection under Article 9 of the UCC. So royalty receivables are accounts or payment intangibles under the UCC, and that is perfected by filing a UCC-1 in the debtor's jurisdiction of organization. If the debtor is a foreign entity, we have to abide by local law, and then also we often file in District of Columbia too, if there is any particular U.S. assets that are of importance. The UCC-1 is prepared and filed immediately upon execution of the documents. And relatedly, IP collateral patents, they are security interest in patents is perfected by the filing of a UCC-1. And it's also supplemented with a filing with the USPTO.
One thing I just want to pause to on the UCCs is the reason we file UCCs is for two purposes. One is that the actual sale of a royalty stream is covered under the Uniform Commercial Code as a security interest. So when you think about security interest, it doesn't only cover loans, it actually includes a sale or participation of a participation interest. And so as a result, what we have to do usually is we file two UCCs. One is a sale UCC where you check the box at the bottom that says it's for a sale. And the second one is the backup security interest. So that's something to keep in mind that's a little different from other financings is if you are doing a sale, you need to remember to also file the sale version of the UCC.
That's
Sorry.
correct. Yep. And then going on to deposit accounts, earlier we discussed collections accounts, operating accounts, or lock boxes. The way that you perfect your security interests in those is only by control. They are not covered by a UCC1. And so that is typically, or that is obtained by obtaining what we call a deposit account control agreement, which is a tri-party agreement between the depository institution, the bank, the debtor, and then also the purchaser. This often sets forth, and this can come in two forms, typically, one being a day one DACA or a springing DACA, as we call it. A day one DACA meaning that the lender slash purchaser has control over the account and can tell the bank or instruct the bank whether a withdrawal or transfer should be made or not, and the debtor has no access or no right to direct the funds. More commonly, it's a springing DACA, which means that is only the control for the lender is only exercised following a notice of exclusive control sent to the depository institution, which states that from hereafter, the lender decides when money can be transferred in or out of that account. And lastly, equity interests. This is of particular importance with respect to SPVs. We obtain a pledge over the equity in the SPV or domestic or any subsidiary that's relevant to this collateral group, and the perfection is defined under the UCC as or is perfected by a UCC1 filing and then as well by control of any certificated equity interests. When you obtain to obtain control over a certificated equity interest, the actual physical certificate is delivered to the lender, usually via counsel, along with an undated transfer power. And once the lender wants to take control or exercise remedies, that undated stock power is then dated, populated, and therefore the lender is able to exercise its rights as the owner of the stock.
So for the priority rules, the reason we have a grant and then perfection are to give notice to the world that there is a security interest, and in bankruptcy, your security interest is protected. Again, highlighting the fact that if you're doing a true sale, an actual purchase, you do want to do that perfection based on, assuming this is a sale, as well as the backup security interest. That being said, even though your security interest is respected in a bankruptcy because you've gone ahead and perfected, you also have to consider the priority rules. And the priority rules are first to file or perfect governs. So if you are the first, so you always want to do the lien searches that Callie mentioned as diligence. Statutory liens and purchase money security interests will have priority under law. Purchase money security interests will not really apply that much on royalty financings into the healthcare industry, but just something to keep in mind. And for example, if you do have significant tax liens, that's going to be an issue because they will prime you. And then in addition, you can agree with other creditors to subordinate their liens or your liens in order to flip the default. So even if someone's there first, you can, be considered second. And we'll go to the next slide, which is on the intercreditor arrangements. So an intercreditor agreement is an agreement where two or more sets of creditors negotiate lien subordination or priority sharing. The reason this applies so let's start with in a standard true sale royalty financing, an intercreditor agreement is typically not required because you're selling a receivable. So that's supposed to be treated as an asset of the buyer, not the seller. And I know the next session in this series, which we'll talk about recharacterization, will go into this much more detail. But that's the idea, is if you have a true sale royalty financing, your risk that your recharacterize is very low. You do have a backup security interest, but generally speaking, you're happy to rely on the fact that your asset is outside of the bankruptcy estate. So typically you don't see them. Sometimes, depending on the senior creditor that may be involved, they will ask to get one. So where there is an intercreditor agreement is important from the royalty financing purchaser's perspective, is where the backup security interest is more critical for some structural or other reason, including because the jurisdiction that you're in does not respect the same rules as in the US. So an intercreditor agreement is a thing in royalty financings as a result. Where a seller does not have existing senior debt in place, sometimes we add in a royalty purchase agreement term sheet-like provisions that are negotiated between the seller and the purchaser of the royalty financing and added to the documentation. Usually this is for the benefit of the seller. So the seller wants to have an agreed form or agreed terms for a future intercreditor so that they can have senior debt in the future that has liens on, assets that may be subject to your backup security interest. And this is sort of a flag for the royalty purchaser that the company might do more secured debt in the future, and that they will want to have an intercreditor agreement. And again, that's partly because you have all these representations in a royalty purchase agreement about not having liens on your assets and things like that. And so this, if you have senior creditor, they're going to have liens. So I'll give you some examples of the kinds of things that are in the intercreditor agreement. So there's really two key concepts here, which is that typically the senior debt provider will want to have the exclusive right to enforce all the liens on any shared collateral. So, that's something that's negotiated. You don't always have that. Really depends on the nature of the company, how much of the collateral is shared versus, how much is really just royalty financing. It depends on how much of the assets are covered by the purchase. Like, for example, if your royalty rights are 60%, 80% of the royalty stream, then, you're going to push back on this a little bit more. So, and then and it makes clear in the intercreditor agreement that to the extent it is the purchased royalty, that the purchaser of the royalty financing stream gets seniority. So it's sort of like it's like a crisscross type of intercreditor agreement, so to speak. The other thing that is covered in these intercreditor sort of agreements is what happens with sales of assets within an enforcement scenario outside of the context and within the context of an insolvency proceeding. And the reason there's a distinction here is because obviously within an insolvency proceeding, you're going to have different rules, including automatic stay, 363 sales, things like that, where, kind of things are out of your control a little bit. So I'll cover first if a sale occurs in an enforcement outside of an insolvency proceeding. And in the royalty purchaser typically will have consent rights over the sale if the shared collateral is not transferred subject to the rights of the royalty purchaser with respect to the purchase royalties. So in other words, if the senior debt provider manages to find a purchaser of the assets that will respect the royalty financing provider's rights, that's something that gets negotiated. Things for the royalty financing provider to consider is, the nature of the nature of the buyer of those assets and whether they're, the same level of creditworthiness. Typically they will be better because this is going to be in a situation where things have gone south. The other aspect to think about is what happens after the occurrence of an insolvency proceeding. So the basic gist of this is that the royalty purchaser will agree to support a disposition of the shared collateral so long as, again, it's subject to their rights on the purchase royalties, or if it's transferred not subject to the rights because bankruptcy rules or proceedings result in that kind of a sale, at least the waterfall provisions will allocate the proceeds of that sale in a manner that preserves the economic sort of allocation that was sort of agreed. The waterfall is highly negotiated, depending on what kind of asset is being sold. For example, if it's pure asset sale of the royalties, all the royalties, it's really easy to allocate. I think it gets more complicated when you're talking about, for example, a bankruptcy and the whole company is being sold. Then how, if they have other assets, how do you allocate? Um, so that's the intercreditor agreement. I'll turn it to Kelly to talk about just enforcement generally.
Sure thing. So, the our colleague Jeff Kraus is going to be giving a more fulsome presentation for the third part of this series on bankruptcy considerations and recharacterization risk. So, this section of the presentation is mostly just focused on things that live in the security document and the four corners of that document. So, some rights that a secured party might have within the document, or typically does have, is upon an event of default, they can notify obligors under the royalty contracts to redirect payment, to the extent that usually this is already plumbed in place by virtue of having a collections account or a lockbox account. But if you don't have that as part of your structure, notifying the third-party obligors where to send the cash is incredibly important. If you do have a lockbox account, well, really just a collections account with a springing DACA, if you have a lockbox account with a blocked DACA, you probably won't have to do this. But you would need to deliver a notice of exclusive control to the third-party account bank, letting them know that the springer has sprung and that the secured party is the only one who should have control of the account going forward, until they cure otherwise. You can also go through an Article 9 disposition or private sale process. That's a statutory process that I think Jeff will cover a little bit more in his presentation. It's also the opportunity to assume or assign the IP licenses to the extent permitted by the bankruptcy code in an insolvency scenario. And then there's also the opportunity to step-in rights that Anthony touched on under those agreements. It might be the opportunity to exploit the IP directly, or via a sublicense. Also, some things that we customarily see are like the opportunity to step in and take care of actions that would jeopardize the collateral, such as litigation or taxes that would create an interceding tax lien.
Okay, so want to cover cross-border issues because what we really have been discussing so far are considerations, assuming that the royalty financings include sellers and collateral providers and assets that are mainly in the US. Where there are material non-US assets or obligors, it's important to remember that not all jurisdictions have a regime similar to the US. A true sale concept may not apply in some jurisdictions. And in that case, the security interest is really not a backup security interest. It may be the primary protection supporting the royalty financing purchaser's rights. The cross-border nature of these kinds of transactions is very fundamental to how you structure them. A lot of times, in the US, we try to do a true sale royalty financing. But if you are in a jurisdiction that doesn't recognize true sale, you really do try to restructure it, the transaction into more of a debt facility. And you want to make sure that you are treating it as debt because in these other jurisdictions, if there is no true sale, you're not going to be able to get the value of future royalty streams after a bankruptcy. And so the only way you can do that is if you have treated it from the get-go as a loan. So it's almost the opposite of what you try to do in the US. In the US, you try to make it not a loan. Ex-US, sometimes you try to make it a loan. So just kind of things that you want to consider really are impacted by cross-border considerations. In addition, some of the reasons why you might have an SPV or a lockbox, or even manage intercompany flows and licensing of IP is because of the cross-border nature of, having to avoid some jurisdictions that are not favorable to a royalty financing provider. And even if there is a mainly US seller, if they own non-US IP and you're getting royalty revenues from ex-US royalties, then you'd want to also make sure that you file in the foreign jurisdictions against the IP there. So, and then just kind of keeping in mind that your governing law, submission to jurisdiction provisions, like you have to keep in mind that those things may have to be modified, where you have a realistic like you're really concerned about being able to enforce in foreign jurisdictions.
Great. And I'm going to talk about just some practice tips and best practices. This is frankly a list of things that we sometimes see go wrong. So of course, the first point is just conducting deep diligence on the obligors and the underlying contracts in which create the receivable, making sure that the things we talked about, primarily the change of control provision, will permit this, or otherwise getting a consent where necessary. Consider your structure, whether there be cross-border issues or just other liabilities, operating liabilities that are out there. Consider whether you need an SPV structure or if it's possible to just purchase directly from the operating entity. Filing UCCs and recording IP liens should happen concurrently with closing. Obviously, there are 1 million things to do after release of pages, but it is important to make sure that as soon as the pages are released, you're hitting send on the request to have those documents filed so they don't slip through the cracks. Obtaining control of the collection accounts to perfect and monitor cash flow. Oftentimes, DACAs end up slipping to being a post-closing condition. Ideally, they would be signed up at closing, but because it's a third-party work stream, it's one of those things that tends to get pushed. Making sure that the DACA actually gets signed up, and you have regular monitoring processes in place to ensure that the cash is in fact going into the lockbox in the way that it's supposed to, are important steps. Making sure that your documents have covenants requiring counterparty consent before modifying royalty contracts to ensure that the risk allocation doesn't change throughout the course of the deal. And then lastly, maintain a robust post-closing tickler system for continuation filings. UCCs last 5 years. They can't be renewed until the period that is 6 months before their expiration. So you cannot submit a UCC continuation at year 4 and expect it to get you another 5 years. So lots of service companies who file these UCCs offer what's called a tickler system, where they will email you and remind you that you need to file that continuation. Alternatively, you can totally keep an in-house system. You just need to make sure you have a good system of record keeping. So if the deal extends beyond 5 years, you are in fact filing that continuation. And I'll turn it over to wrap it up.
Yep. Thanks, Kelly. And in conclusion, a royalty financing strategically aligns with an investor's return with a borrower's revenue growth, essentially giving them access to capital before the revenue streams start coming in. And by taking and properly perfecting the security interests in the royalty stream, underlying IP related proceeds and also other related assets, the investor slash purchaser substantially mitigates their risk and elevates its priority in the capital structure and preserves its optionality in distress situations, if or when it comes down to it. And as we touched on throughout this presentation, careful drafting, rigorous perfection, and drafting techniques, as well as proactive monitoring, are therefore indispensable and a true priority to ensure that the lenders are secured perfectly, and also to ensure that they're made whole at the end of the deal.
I want to thank all of our speakers for a terrific presentation. I learned an enormous amount, and I know our viewers will as well. So again, if you have not registered for the 3rd program in our series, please make sure to do that. And if you need to catch up on the 1st program, you can get that through our BCLE platform at bcle.berkeley.edu. Have a wonderful rest of your day.